Trump Legal Cases Daily Digest. December 29, 2023. Happy holiday season. This week's focus was on Trump's anticipated appeal to the Supreme Court following last week's ruling by the Colorado Supreme Court, barring him from the state's 2024 GOP presidential primary ballot. The ruling is based on a post-Civil War constitutional amendment preventing insurrectionists from holding office. Some scholars, quoting historical facts, believe that the amendment's coverage extends to all individuals holding any office, civil or military, under the United States. It's important to note that Trump's status on the ballot, as the Republican frontrunner, doesn't impact his ongoing 4 criminal trials. The court schedules are anticipated to become more active in the new year, with oral arguments scheduled for January 9 in the D.C. Circuit Federal Appeals Court to decide whether Trump's federal election obstruction case should be dismissed due to presidential immunity. Today, the D.C. Circuit Court of Appeals ruled that Donald Trump has no immunity in the January 6 civil suit. D.C. Appeals Court rejects Trump's claim of immunity in January 6 civil suit. In a significant legal development, a federal appeals court ruled on Friday that former President Donald Trump is not entitled to absolute immunity from a civil lawsuit filed by a group of U.S. Capitol Police officers. The lawsuit centers on Trump's alleged involvement in the January 6, 2021, assault on the U.S. Capitol. The 3-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit based its decision on a recent ruling in a separate case, rejecting Trump's argument that he is shielded from civil liability due to the official functions of the presidency. In their unsigned opinion, Chief Judge Srinivasan and Judges Bradley Garcia and Judith wrote their opinion, quoting from the D.C. Circuit's earlier ruling stating, whether President Trump's actions involve speech on matters of public concern bears no inherent connection to the essential distinction between official and unofficial acts, quoting from the D.C. Circuit's prior ruling. This decision reinforces the precedent set by the earlier case, where the court dismissed Trump's claim that his actions related to the January 6 attack were within the scope of official presidential duties, clearing the way for the lawsuit to proceed. Melissa Quinn of CBS noted that in its unsigned opinion Friday, the 3 judges said the case before them is indistinguishable from the other dispute and said Trump's argument that he has immunity fails. The Trump campaign has not issued an immediate response to the court's decision. The ruling signals a notable legal setback for the former president, as the appeals court rejects his claim of immunity and allows the Capitol Police officer's civil suit to advance, raising questions about the potential legal ramifications and accountability for Trump's actions related to the tumultuous events of January 6, 2021. Framers' intent on the 14th Amendment's disqualification clause. In a meticulous analysis of the 14th Amendment's disqualification clause, the historical context and intent of its framers, Stephen Portnoy on ABC News shed light on its application today, particularly in challenges to former President Trump's eligibility in some states. The original House-passed version of Section 3, which pertains to disqualifying individuals who adhered to the late insurrection, explicitly read, until the 4th day of July, in the year 1870, all persons who voluntarily adhered to the late insurrection, giving it aid and comfort, shall be excluded from the right to vote for representatives in Congress and for electors for President and Vice President of the United States, according to congressional records. During the Senate's extensive debate on the amendment in 1866, said Portnoy, Senator Jacob Howard of Michigan, a leading Republican debater, advocated for a comprehensive exclusion of former Confederates from government service, extending beyond voting rights. He expressed, "I should prefer a clause prohibiting all persons who have participated in the rebellion from all participation in offices, either federal or state, throughout the United States, emphasizing the potential benefit to the nation." Howard's proposed revision, ultimately ratified, included crucial qualifiers, specifying that individuals excluded from government service must have violated prior oaths by having engaged in insurrection or rebellion against the Constitution, or given aid or comfort to the enemies thereof. This historical insight illuminates the framers' nuanced discussions and decisions that shape the application of the 14th Amendment's disqualification clause today. In the upcoming scrutiny of the 14th Amendment Section 3 by originalists on the Supreme Court in 2024, there will likely be a focus on the framers' intent regarding the applicability of disqualification to any rebellion beyond the late insurrection. The debates in the Senate in 1866 provide valuable insights, including an exchange between Senator Peter Van Winkle of West Virginia and Maryland Democratic Senator Reverdy Johnson. Van Winkle sought to lower the threshold for congressional amnesty, prompting Johnson to question the omission of excluding certain officials from disqualification. Vermont's Justin Morrill stepped in, emphasizing the amendment's explicit coverage of individuals holding any office, civil or military, under the United States, bringing an end to the discussion. This historical exchange may play a crucial role in shaping the court's understanding of the 14th Amendment's disqualification clause. Maine GOP lawmaker initiates impeachment proceedings against Secretary of State over Trump ballot disqualification. Maine GOP state lawmaker, John Andrews, is seeking to impeach Secretary of State Sheena Bellows following her decision to disqualify former President Donald Trump from the state's 2024 Republican primary ballot. Bellows invoked Section 3 of the 14th Amendment, which prohibits individuals who engaged in insurrection from holding office, as the basis for Trump's disqualification. Andrews contends that Bellows' action is rooted in hyper-partisanship, expressing concern over her partisan appointment and accusing her of disenfranchising 360 Maine voters. Bellows defended her decision, emphasizing that the 14th Amendment Section 3 does not require a conviction but only engagement in insurrection, citing the events of January 6, 2021, as evidence of an insurrection in which Trump participated. The dispute reflects broader tensions over the interpretation of constitutional clauses and their application in barring individuals from the electoral process. During an interview with Fox and Friends on Friday, Senator Andrews expressed his concern over Bellows' decision to disenfranchise 360 Maine voters through a partisan move. He further explained that the clause was originally intended to prevent former Confederate soldiers and officers from holding positions in the U.S. government or military. Maine Democrat representative criticizes state's decision to exclude Trump from 2024 primary ballot. Democratic Representative Jared Golden of Maine expressed criticism over the decision by Maine Secretary of State Sheena Bellows to remove former President Donald Trump from the 2024 Republican primary ballot. While clarifying that he voted to impeach Trump for his role in the January 6 insurrection, Golden emphasized the importance of adhering to the nation's laws, asserting, "Until he is actually found guilty of the crime of insurrection, he should be allowed on the ballot." Golden's stance underscores a commitment to legal processes and a reluctance to preclude individuals from electoral participation without a formal conviction. The move by Bellows, citing the 14th Amendment's clause on insurrection, has triggered a unified response from the Republican Party in support of Trump, with national Democrats showing varied opinions on the matter. While many national Democrats chose to remain silent, some applauded Trump's removal from the Maine primary ballot. Representative Shelley Pingree, Democrat Maine, wrote online, "The text of the 14th Amendment is clear. No person who engaged in an insurrection against the government can ever again serve in elected office." She continued, "On January 6, 2021, Donald Trump incited a violent mob to block Congress from certifying the Electoral College, and overturn the 2020 presidential election. Our Constitution is the very bedrock of America and our laws, and it appears Trump's actions are prohibited by the Constitution." Representative Bill Pascrell, DNJ, said on X, "Donald Trump incited a violent riot to overthrow American democracy. Of course, he should be banned from the presidency forever." Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.